Bucketeers. Good to see you all here. Welcome to the bucket courses. I'm Joanne Bundy. I want to remind you to please silence your cell phones and turn on your tea coil. We'll be ready to go. You'll notice we don't have any tables set up this morning, and that's because we have a full classroom. And when the planning committee has to choose between having tables in the room or having you in the room, you win every time. We're taking a bit of a departure from our usual kind of venue for the bucket courses this morning. We're going to talk about the judicial system. And we're fortunate in having Judge Stephen Carroll, who, as you see, is a senior district court judge in the state of Iowa. I urge you all to be on your good behavior. I'm sure this is the only venue in which you want to appear in front of the judge. So without further ado, I hope you will give a good welcome to Judge Steve Carroll.
Thank you, Joanne. Can you hear me back there? Okay. I'm honored to be speaking to you today. I consider this a real gift for me to be able to talk to you about my passion and love for the law. When someone asked me if I liked being a judge, I guess I still am a judge, I always respond with an unqualified yes for several reasons. First of all, I have always felt privileged and blessed to serve as a judge. If you'd asked me when I was in 6th grade what I wanted to do, I would not tell you that I would want to be a judge. I wanted to play for the Chicago Bears. That didn't work out. Second is, you will see as we go along in the series, judging to me was a challenging job. To be sure, it wasn't, I would not say it's rocket science, but it drew upon all the parts of my education: math, physics, chemistry, literature, and history, to mention a few. Third, I got to work with folks every day who were among what I consider the best and the brightest lawyers. I take great pride in my profession. They were always honest and direct with me. In our judicial system, there is absolutely zero tolerance for lying to a judge. Generally, you get to do it once, and then you will find yourself suspended for a period of time from the practice of law. Finally, when I went to bed every night, I didn't look back and worry about what I had done during the day. I actually looked forward to going to work the next morning. So I thought about all those people who really didn't like their jobs, and thank you. And I appreciated that I could get up in the morning and go do mine. When I was a kid, I used to walk past lawyers' offices and wonder what went on inside. The law was a big mystery to me. In my first couple of years on the bench, I experienced what is referred to as the imposter syndrome. When I first would go up the steps, I would wonder, who am I to sit in judgment of the people in front of me? As time went on, that feeling dissipated, but I always remained thankful to be in that position. Sometimes I sat up there like many judges, probably like a number of you present and former faculty members, and thought, wow, they are paying me to do this. It was fun. I often wanted to pinch myself. The last thing is that I feel blessed to have been a judge because I really can't do anything else. You know, talk to me about a carburetor, the conversation will be short. We're going to have three sessions, excuse me. We're going to talk about judging in Iowa with specific emphasis on the district court. The court of general jurisdiction, that's my court. Why are we going to emphasize that? Because it's what I know most about, and so we'll talk about that. Then the second is that we're going to talk about the awakening of the Second Amendment. It was awakened in 2008 with a case of D.C. versus Heller. And I read the billing. Judy Hunter, really, I give thanks to her. She gave me a lot of help in getting here today. And she and I billed the talk on the Second Amendment as what does it really mean. I look back on that, that's sort of really presumptuous. I don't presume to tell you what the Second Amendment means. I don't think anyone really knows at this point. But we'll talk about it for an hour and a half or so and see what you think. I'm going to try to present as, scare quotes, fair and balanced as I can. Then we're going to have talk about a murder case that I presided over in 2010, State of Iowa versus Mark Becker, and take you through that murder case. So that'll be sort of a specific application of some of the things we're going to talk about today. And with us that day will be Mr. Doug Schuler, who is foreperson of the jury. Mr. Schuler and I have had about 3 board presentations together. I've learned a lot from Mr. Schuler and what went on in the jury room. I wished I'd learned those things a little earlier in my judicial career. I don't think we treat juries well, but we'll talk about that third session. Also joining us will be Mrs. Joan Becker, the Mark Becker's mother. There's a video that I'll talk about next week, or she talks about the Becker family. I hope you can get online and look at that. It's about 15, 20 minutes. But the struggle she went through with Mark and trying to get him care for his paranoid schizophrenia, which they didn't really know he had. No one shared it with him. And with the, she'll just confirm what we already know, that there's a crisis in the mental health area, and that crisis resulted in a death in Parkersburg. Well, I have to... I would walk away from murder cases often depressed for about a week, but we look for humor in the courtroom. Most of the time we're seeing people at their worst. They really don't want to be there. They want to be there in my courtroom as much as I want to see the hip surgeon. But we do have funny times in the courtroom. First of all, there's the man who would wake up dead. This was a domestic abuse case, and then we go to no room in my briefcase for the client's head, and then we have none in the courtroom. But first one, the fellow had trouble with his wife. She ran around the house. He's talking to me in a domestic abuse case, and he testified that his wife would chase him with a ball bat, and he tried to get away from her, so he took to locking the bedroom door, and then one night she picked the lock, and she never would beat him about the head so people could see it. She usually beat him about the legs or the midsection. So he's telling me about how she picked the lock and came in and beat him one night. And he said, "Judge, you've got to do something about her. One of these mornings I'm going to wake up dead." And I said, "Sir, that's impossible." He looked at me and said, "You don't know my wife." So I just let that one go. The next was the no room in the briefcase for the head. It was another domestic abuse. Not that I saw any humor in those, but this time it was the guy, and he would beat his wife, and he also would take to beating her where it didn't show. She had long hair, so he'd cuff her up the back of the neck, and the lawyer had her testify, and then said, "Your Honor, I'd like to have her show you her neck where he's been hitting her." I said, "Okay." Lifted up her hair, and I could see red marks, and then the lawyer turned to me and said, "Your Honor, I offer my client's head into evidence." She's a young lawyer, and I just looked at her without breaking a smile and said, "I'm sorry, Consul, I have no room in my briefcase for her head." Then I right away after that asked her where she went to law school, and if it was Iowa or Drake, they were going to get a call from me right away. It wasn't, it was a California school. The third one, I'm trying a medical and pharmaceutical malpractice case. A woman had a revision on her knee surgery, and it involved, it was against Mercy Hospital, which is run by the Sisters of Mercy out of Detroit, and it was also against the two orthopedic surgeons, both of them, well respected in the community, and both had just retired, just the thing they wanted upon retirement, and it was against the pharmacist at Mercy Hospital as well. Then it was against the nursing home where she went to, and the nursing home doctor. And the lawyer's from California, and he's a young guy, 32. He was pretty hard for me to manage. He always wanted to stand up, and I said, "No, we don't do that in Iowa. You're not in California. Sit down, Consul, and examine from the table." And he would bring in clips to me in the morning, showing me these multi-million-dollar verdicts that he got in California. And I wasn't impressed. I said, "Yeah, but Consul, you're in Iowa. And the last 30 medical malpractice verdicts I'm aware of, plaintiffs didn't win any. They're 0-30 against the physicians." I said, "Don't count on a big verdict here, if any." I tried to give him a little reality therapy. Well, one afternoon at the break, I walked out of the courtroom for lunch, and my court reporter usually stayed after that because she became my ears and eyes in the courtroom to tell me what happened after I left. Lawyers didn't catch on to that, So this plaintiff's lawyer really took off on the defense lawyers from Des Moines and said, "I can't believe what you did. This is the lowest thing I've ever seen in my practice, in my trial practice." And they looked stunned, and they said, "Well, what are you talking about?" And they said, "Here's the case against Mercy Hospital, and you had a nun sitting in the front row the whole morning." And I have a picture of that nun. My court reporter turned to the young lawyer and said, "I would not talk to the judge about that. The judge is dating her."
Did you know that story?
So that we do have some fun times. Questions for today, and we're not going to, I think, answer them all, but what are the different courts? How are they functionally differentiated? How do you become a judge? What training do we have? What do we do? How do we do it? Can a judge do whatever she wants? In other words, I think that word should be constraints instead of restraints as I look at it now. Judicial constraints. I'm going to be forced to use some words in this series that I really don't like to use very often. Right, liberal, and conservative. I think for the most part they obfuscate more than they clarify. But right. I don't, when people say, I have a right to do something, that's pretty much the end of the conversation, because the other party will say, no, you don't. That's sort of our Second Amendment discussion. I have a right to carry a gun. No, you don't. Yes, I do. I had a law professor early on, young guy out of Yale, that really helped me out with that. He said, if you're going to talk about a right, talk about a right in a specific context. The right to do whom, in what situation, and at what time. Generally, you'll see that, to me, I'm a sort of a realist in judicial philosophy, and to me, a right means something that the court says you can do. Court says you can't do it, then you don't have a right. Now, I know that could lead to some discussion with religious philosophers about natural rights, but we don't apply those in the courtroom typically. It's pretty tough. Liberal and conservative. When we talk about the Second Amendment next week, I'll use those words. I think they tend to, when I say liberal or conservative, and I'm going to use them, not in a pejorative sense, but in a descriptive sense, just as sort of, if I say to you, gosh, conservatives and Republicans back gun rights, you know what I'm talking about. So I'll use it in sort of shorthand form. Trial courts in Iowa, we have 3 tiers. Trial courts, we have an intermediate appeals court, and we have the court of last resort, the Supreme Court. And I've got coming up a slide that kept getting more, as my mother used to say, discombobulated as I worked on it. Here it is. These are the, let me try this. These are actually the district courts. We have 116 at this level, and in my court. And then we have associate district courts, and then of course some of the people I've seen, and maybe you've seen, the magistrates, they handle traffic tickets. Total filings at this level was almost 740,000 last year. District court, we handled 179,512 cases, 116 judges, do the math. There were often mornings when I would look at 40 different files. Some mornings I do 8 to 10 sentencings, taking about 5 to 10 minutes each. People would say, what do you do? I said, well, I sort of work on the assembly line, especially in the area of criminal law. Here's our Court of Appeals. There are 9 judges on the Court of Appeals, a number of women, I think 3. Supreme Court, 7, all men again. And what happens, we have sort of an odd system. Only 3 courts in the nation have this type of system. But we have a direct filing system, so all these appeals go up to the Supreme Court, and then it's a deflection system. The Supreme Court then can send cases down to the Court of Appeals. So when you get to be, I shouldn't say this on tape, but I'm jesting, but you get to be the Supreme Court and choose what you get to keep. See how it comes out. The Court of Appeals last year had submitted to them 1,168 appeals coming back down. They decided 1,226, that's 136 per judge. They're cranking them out 8 to 10 a month. And as we'll see, this court happens to be what I refer to as an error correction court. I'll get to that in a bit. And then the Supreme Court, 99 were filed that they kept, 63 civil, and they decided 14 per judge. Yeah, if they're filed, they kept them all, that's right. So most of them are civil, about a third of them are criminal appeals, and 14 per judge, a little over one per month. And one thing that I think is lamentable about the law over the years, I went on the bench in '85, is that it seems like appellate courts think their rulings have to be longer. I don't know if any of you knew Harvey Uhlenhop, he's a Grinnell graduate in the 50s, great justice. When Harvey would write a decision, he'd say, the issue is, set it out, and then give us about 7 or 8 pages. Just a trial judge's friend. Our Supreme Court, it's not unusual to have decisions 40, 70, 80 pages long. So part of my job is I have the time to sit and read those, and part of my job is to read them and then pass them on in the form of a bench, some comments in a bench book. That's part of my job, is to work on a trial bench book for the trial lawyers, or work in the new judge seminar. So this is an unusual system. They go up and they come back down. We have fine jurists on the Supreme Court and on the Court of Appeals. We are, our court system is usually very highly ranked in the country. There's a national center for state courts that keeps statistics. Well, here a litigant has the right to a decision in the first level, and you have to get a ruling. You're entitled to a ruling from the Court of Appeal. The district court. The trial court cannot ignore the claim. So if something came in, and we did whatever came in the door as a court of general jurisdiction. So there were times I wanted to say, "Wow, this is really hard." But you don't do that. You just well, you can say it's really hard, but you can't pass it off to anyone else. And then the loser has the ability to appeal, and the appellate court must hear that appeal. Now my court, as I say, was general jurisdiction. I'm not going to go through these in detail, but these are some of the things: family law, criminal, probate, personal injury. One of my good friends, his wife worked for the clinic in Mason City, so I did quite a few of those up in Mason City. Asbestos case, toxic torts, bad cattle feed. I had a case where a farmer didn't tell anybody he was storing chemicals, and there was a fire in his barn, and it resulted in a toxic cloud over 3 farms. And then there were other torts. I did lawyer, accounting malpractice, and contract actions. There are 2 main functions of the judicial system. First of all, let's not have people fighting on the street. It's for peaceful resolution of disputes. And then to create and refine legal standards is another function. Yes?
Where is the court for people, children or young people? Where does that fit in?
Okay, the question is, where is the court for young people? And we have, when I showed you the district court, the lower courts, part of that district court system is associate district judges, a little lesser jurisdiction, but they do the juvenile work. It's very specialized. I prosecuted, I defended, and when I prosecuted, I did juvenile work, but as a judge, I didn't do much. But we have courts set up because we like to follow the children through the system. We don't want different judges handling the same file. And our previous judge, Justice Marcia Turnus, really helped in refining that system. You're welcome. So, you know, my job was to decide disputes. Those decisions have no precedential effect. They're just simply the law of the case. And sometimes they like that to go away. I had an open meetings law case with a school board up in northwest Iowa, longest case I ever had, 5 months to me on the bench. And I ended up awarding $160,000 attorney fees. The Iowa Association of School Boards, bless them, sent out a note and said, we've got this terrible ruling from a trial judge up in Winnebago County, and we just want to show you we stand behind our members. We are paying the school board's attorney fees for $160,000. Well, I thought I was on pretty solid ground, and you know, when you file a ruling, you really are convicted about it. And so I figured, oh, they don't want this to be appealed. They don't want it to be the law of the state. So, you know, and I wished I could have written their note to the school districts, because I would have changed it and said, wow, you know, if we all do this, we're in trouble. But they, you know, and I can understand their position. The lawyer was happy. He got $160,000 for doing that. Supreme Court is a law creation function. Sometimes we help. And I have a Fourth Amendment case. Sometimes the whole outcome, or the outcome relies on whether certain evidence comes in. And if we judges realize that, we allow the parties to just stipulate to the facts. They agree these are the facts, and we don't agree with your decision that this evidence comes in. And if they want to make the record, I will help them make the record, knowing that they're going to appeal it, my ruling. I've got a couple examples later on. So we trial judges do help in the creation of the law. That's not my job, but if somebody comes to me and says, I think the law should be changed in this area, I'll be glad to say, you know, Consul, I will help you get the record made so you can appeal this. It didn't bother me to get appealed. Intermediate courts are the Court of Appeals hybrid, and they serve both dispute resolution and law creation. Our Court of Appeals here really doesn't do a lot of law creation. Dispute resolution, in the context of the appellate court, dispute resolution function is often called error correction. And, you know, I make a decision, it goes on up, and the appellate court will review it for content of the law, how I applied the law to the facts, and sometimes to the findings of facts. But the appellate court's not going to mess too much with my findings of fact. Anybody have an idea why? Okay, well, they won't, because same reason we do not mess much with jury verdicts. The finders of fact, and if it's tried to me, I'm the finder of fact. I'm in the best position to look at the credibility of the witnesses and decide who should be believed and who should not be believed. And if the appellate courts start substituting their factual judgment, we are going to have a logjam at the appellate courts. So we judges, one of the tips of judging I give new judges is, if you're convinced of your position, one good way to have it be a firm decision is beat the party on the facts, make your fact findings very, very tight, and it's not going to go anywhere. Okay. Selection of judges. We can get into that. And the major issue there is what do we want? Do we want to give priority to judicial independence or political accountability? This is my redundant comment. Which is the greater concern to us, threats to independence or insufficient judicial accountability? Then a related question is, how do we get the most competent judges. What do we look for? Well, most agree that integrity and impartiality is what you're looking for. About 2,400 years ago, he said it best, and when I swear in new judges, I'll use this, but you know, you want a judge that's going to hear courteously, answer wisely, consider soberly, and we don't mean there that he's not or she's not been drinking, and to decide impartially. And I'll talk about how we try to quantify those things in looking at performance of judges. Okay, here's a major issue. How do we balance the competing and opposite objectives of accountability and independence? And it goes back and forth. Article 3, as you know, from Professor Drake's previous talk on the Constitution, it allows for the appointment of judges for life, federal judges. It's still that same way. That was the early version, too, that occurred in many states. So we're really placing an emphasis on independence. Well, the pendulum, as I'll talk in a little bit, is swinging that way, and I think there's a real threat to judicial independence brewing. Somebody have a question? Or?
I've got a question, Steve.
Yes.
Going back to the slide where you said there were 7 or 8 different kinds of cases that you have, how do you master the law? I mean, each of those areas has its own law. But I would think that the challenge, I'm thinking of judicial appointments here, the challenge of intelligence, knowledge of the law, and so on must be huge.
Yeah, the question is, if I can restate it accurately, is with all those different areas of the law that a district court judge has to handle, how do you, well, to do it? You stated it more artfully. What?
How do you know the law? I mean, each of those areas has its own specialized branch of law, and you have to know all of that. I mean, you're basing your judgment on law.
Yes.
You have to know the law.
How do you know the law? Actually, I'll back up just a little. The important thing to me is asking the right question. We're trained in law school to identify issues. And how I decided a case is I would ask myself, what is the big question to be answered here? And then I would figure out what questions I needed to answer to get to that question. So I would first outline what do I need to know. And then we had one law clerk for 6 judges, and law clerks just out of law school. So I did most of my own research. You handle some cases, as an experienced judge, you know, the standards for medical malpractice, probate things, they become sort of almost intuitive to you after you do them long enough. But another answer to your question is, that's the function of the advocates. If I was wondering about something, I could get a hold of the lawyers and say, brief me on this. I want to know what you think the law is in this area, the law that I should apply. Had to be careful because they're advocates. So I'd read all the cases, which meant I spent a lot of time at night. Sig and I the other day were talking about how much time professors put in, and put in a lot. I put in a lot of nights and weekends, in reading all the cases the lawyers gave me, because sometimes they state this case stands for this proposition. I'd read it and go, huh? No, it doesn't. And then experts are not. We're supposedly experts on the law. On the facts, experts would be very, very helpful. So, does that answer your question? Or?
It's a process. Each time.
Pardon?
And what I'm taking from that is that you're saying in each case it's a process of digging in with help to examine the law that applies to that case?
You just dig in. I'll give you a couple examples. In the Mark Becker case, the jury was out 3 going on 4 days, and I had never had a case. I've been a judge almost 30 years. I've never had a case where a jury locked up. And so I didn't know what to do with that. I knew that I had to be real careful about declaring a mistrial because of double jeopardy. You know, and one judge had done that, declared a mistrial too soon. Guy couldn't get retried on an important offense. So I spent the whole weekend researching. It happened on a Friday, and I called a timeout in the trial. I recessed early, 3:30, and I worked all weekend on that question of when should I pull the trigger and mistry the case. I made some conclusions, and then I met with the lawyers by phone on Sunday night and let them know what I intended to do. Let me give you another example. This is not so much on the law, but on the facts. When I was a young judge, and I prosecuted for a while, we didn't have DNA. When I prosecuted a rape case or sexual abuse case, the best we could do is decide whether the perpetrator was what we call a secretor, which means secrete blood type into the seminal fluid. And we thought we were just, you know, in hog heaven if we had a secretor and we could at least get the blood type of the defendant. Doesn't narrow it down much. So we didn't have DNA when I was first a judge. And then my first murder case with DNA, I had to decide, do I let this newfangled thing called DNA into evidence? You know, and so I had experts testify about peer review, about acceptability of the scientific method, and I decided, yes, I'll let that into evidence. And the person testified at that time, the exclusion was like 1 in 30,000 people. But I spent all weekend on that. I pulled my chemistry books off the shelf. The Federal Judicial Center has a great book about that thick on DNA, and so I got to figure out what alleles are and the molecular structure. In other words, I learned enough to not appear real stupid in front of the expert witness. But I spent the whole weekend in my den at home learning about DNA. So that's what my last case was an asbestos case. Lawyers from New York, Chicago, Dallas, and Harvard pathologists testifying. And I learned a lot about the different forms of asbestos and how lethal they are, differentiated according to the type of asbestos. Some sort of stick in your lungs a little better than others. But I didn't know any of that. I couldn't even say mesothelioma, you know, when I started that case. So it's sort of like I told my son, he said, how can I be a better student? And I said, put butt in chair. And that's what a judge, that's what a judge has to do as well. Long answer to your question, but it's a great question. People assume, you know, judges know the law. We really don't. You know, my wife would say, why did Iowa decide the same-sex marriage case that way and Arizona went a different way? And I said, I don't know, but give me a half hour. And I came back and gave her an answer through the wonders of the best research system in the world called Google and Lord Thompson Publishing in St. Paul, Minnesota. I've got a subscription to that. Well, the balance early in the Republic I have about 3 minutes to get this pen. Federal 78, and then a favorite guy of mine, Alexis de Tocqueville. Boy, I thought I was put upon when I majored in American Studies and had to read that for my senior comps. And that thing is so dog-eared now. But as you recall, Federal 78, we're the weakest. Sword, or we don't have power over the sword or purse. Since the same-sex marriage case, 2009, judges have had one raise, 2.5% last year, none again this year. It's the longest I've ever known. Other state employees got 11 to 12%. We're still being, and excuse me, legislators, but it appears we're being punished still for that decision in the pocketbook. I feel sorry in it yet for the judges, and it really affects our recruiting. You know, we've got to give independence, according to Federal 78, to judges, because as the weakest branch, we got a little pretty tough job to fend off the other two branches. What's going on now? Complete independence of the courts is essential in a limited constitution. Judicial review, Marbury versus Madison. Not sure we'll get to it today, but you know, if you need interpretation of laws, the courts. Hold that thought when we get to Marbury. Tocqueville, you know, he came over ostensibly to view our prison system and really got intrigued with this thing in, what, 1830s was it, I think? Really got intrigued with this new thing called democracy, and he was pretty prescient in a lot of his observations. He said most political problems are eventually resolved in court. Bush v. Gore, Citizens United, think about Roe versus Wade, climate change, which I don't think ought to be resolved in court. And then he's concerned about the tyranny of the majority. That, you know, if we're going to have a democratic system, people get the idea we should vote on everything. And if we do that in a pure form, then who's going to win? The majority is always going to have their way, and I'm sort of simplifying what he had to say. But he said that's a real potential danger in a democracy, in what can we have to push back and sort of keep this thing in balance. The judicial system, judges and lawyers, that, you know, we can get between the power of the government and particularly the minorities. And I get pretty upset when I hear about people in a broad way saying there's racism in the judicial system. Because one thing that, you know, judges really pride themselves. You really want to hurt my feelings, say I'm unfair. You can call me anything else, please, but not that. And most judges I know really take seriously their job of protecting minorities from what they determine to be the oppression of the majority. The same-sex marriage case in Iowa in 2009, Barnum versus O'Brien, is a good example. The court stepped in and said we have this perceived minority who we think are getting the short end of the stick here and not being treated well. We are going to correct that. We're not going to wait for the legislature to do it, which was an option, obviously. How am I doing? Are we ready for a... Oh, good. That's what my court attendant would do. She'd come in the courtroom and I got to tell you, I think you'd be a great court administrator.
Thank you for taking your chairs, ladies and gentlemen. Before we start our second half, I want to tell you about an addition that we have for our schedule this spring. It isn't on our bucket stuffers, but on May 4th, which is the Wednesday after this class closes, May 4th, we're going to have a special day, which will be Byron and Heffley Worley and his wife Karen, who put together a really fun talk about the history of buckets. And I don't mean the history of the bucket classes, I mean the history of buckets, as in pails. And for those of you who have attended Byron's courses before, you know that it's going to be fun. We're going to have some special treats. There's no registration and no tuition fee, but I advise you to get here early that day. That's on May 4th. And now we'll go back to a more serious topic about the judicial system with Judge Stephen Carroll.
I'm going to pass around some note cards. If you have any questions, jot them down, please. I'll take a look at them between this week and next week. And also, if there's any particular area you wanted me to talk about a little bit, I'll do that as well. Can you hear me, Lois, back there again? Okay, thank you. We have about 35 minutes, and I wanted to talk a little about judicial selection, judicial retention, and then how do judges decide cases. I'm going to lop off. We were going to talk a little about Marbury versus Madison. I don't think we'll do that today. But if I seem like I'm hurrying through the judicial selection, I am. So I'd like to talk about the question that Professor George Drake raised on how we decide cases. A couple of different ways to do it: partisan, nonpartisan. You can have a gubernatorial or legislative appointment. Iowa uses a hybrid plan. It's called the Missouri plan because Missouri started doing it in 1940. We started in 1962, and thanks be to God, we started doing it by means of a constitutional amendment. So we'll continue doing it for a while. There are three main steps in merit selection. You've got to evaluate and select the candidates. Then we have governor's approval, and then we have periodic retention elections. So the first part, the public does not have a lot of input, and then retention is where you have some input. The Iowa balance, nominating committee chooses the merit. I'll go through this. And for example, if politics are irrelevant, I've served on 5 nominating commissions, not because I was such a good judge, but I was the most senior. So I got to do it, and I did it during the period of time where we had Democratic governors for a while, and the governor gets to appoint the 5 laypersons, the lawyers get to appoint 5 lawyers, and then the judge on the commission is the tiebreaker if need be. But I had a nice guy, he's a union steward. Obviously you knew which party he's with then, Democratic Party. And we had a very good county attorney. This has nothing to do with her. And he could tell that we liked her. We were thinking of sending her name to the governor. And the union steward turned to me and said, "Oh, Judge, I don't think that Governor Culver's really going to like having us send a Republican." And I stopped the proceeding and said, I don't want to hear anybody say Democrat or Republican again during this meeting, please. And this makes no difference. About the time I was appointed by Governor Branstad in '85, he appointed a really good friend of mine. I'm not going to reveal my political persuasion, but Paul Reffa, who's Irish, Democrat, Catholic, county attorney. So the important thing is you get through the commission, there are 2 steps, and I've counseled people who want to be judges on how I think this should be done. Judge Riffle and I picked out a young man we thought would be a great judge, and he turned out to be. But we visited with him and said, essentially, here's how you do it. Get through the commission, and then the governor appoints. So you want to find out who's got the governor's ear. And that's not too difficult to do. I've had great discussions. Governor Branstad is a good listener, in my opinion. He listened to me rant and rave about the death penalty. He supports it, I do not. And at dinner one night, and we left as friends. But we have regular retention elections. This is the sole question you'll see on the ballot. So Judge Carroll will be retained in office. You have to get a majority, and usually we get 75 to 80%, but not always. It's designed to remove politics from consideration. Now that sounds pretty easy to get over 50%, but you take an off-year election when not many people vote, like when we lost 3 Supreme Court justices. You figure 25% of the people, or 20 to 25%, are going to vote no. In fact, I had a good friend at a previous parish who was an engineer. I won't name him, but he said, I just vote no against all the judges for the principle. And I said, oh, please don't, And so to get that other, if you're already at 75% going into it, the danger is you only have 25% this way, not 50%. So the merit system, there's no need for information on candidates' political and legal positions. We're prohibited by judicial ethics from endorsing a candidate. I did go to a caucus this spring, but I did not go into the room. I stayed outside the whole time. Voter information. You only vote on retention. You do not vote on who gets to be a judge. What is the relevant information? Well, it's not the judge's personal views or political views, but it's how is this judge doing? What is his or her performance? Do personal views affect judicial decision-making? Well, remember John Roberts at the confirmation hearings? Justice Roberts said, we just call balls and strikes. It really doesn't make any difference what I think about in terms of personal preferences. Oliver Wendell Holmes said, the life of the law has not been logic, it's been experience. I had an exam question on that. I wish that I knew what I know now about it. I would have done better. But so the two different views. Personal effects or opinions. We're talking about matching colors in deciding cases in a little bit. Do they help? Well, all else being an equal place, yes. Political views. Politics creeps in because laypersons are named by the governor, but that's about it. It's very limited. If retention properly views as a means for reviewing competency of a judge, then what type of information do you all need to make an informed decision when you go into the voting booth? Well, the personal views of the judge should not be important at all. But they can get in if the judge makes of an issue by improperly deciding cases. But if the judge improperly decides a case by injecting her own opinion, that judgment is probably going to be reversed for not following the law. Voters make this a retention issue by attacking a judge for deciding a case contrary to their views. Bob Vanderplatz and the movement in 2012. And we didn't do a very good job responding to that. I hope that he is really distracted this time around by Senator Grassley's deal. Stays out of the Iowa judicial system. Second, third here, damage the merit selection process, injecting the personal views of the judge. I had fun. I have to draw things out. Here's how judges are selected. You get the candidates, they go to the nominating commission, 5 laypersons, 1 judge, 5 lawyers, and then we pick 2. If it's for an appellate position, there's a statewide commission, pick 3. Then it goes to a young Governor Branstad. It's about how he looked when I was appointed. And then there's our judge, Chief Justice Mark Cady, an excellent jurist, good friend of mine. He and I served together up north. Justice Cady was a magistrate, just associate judge, district court judge, court of appeals, and now on the Supreme Court, so he knows what's going on. These are additional resources. If you'd like these, you know, make a note on that and give me your email address, I'll send it to you. Retention. Again, very simple question. You get more than 50%, you're a happy judge. You get less than 50%, and you're out looking for a job, which you really didn't count on. Probably going to use that gavel to do some, well, never mind. So judicial selection is a prospective view, what's going to happen down the road. Judicial retention is a retrospective view, how well has this judge performed on the bench. Has it worked? Most of the time it has. 2010 we lost 3 excellent justices, including I studied with a woman quite a bit, not quite every day, but a lot in law school, Marcia Turnus. I was smart enough to hook up with really smart people, and she turned out to be the chief justice. Only one time before 2010 had we had a judge voted out, and this judge got in some trouble, Des Moines judge, and the Des Moines Register got him by the pant leg. And when that happened, we knew it was over for him. You know, many judges, I went to meetings after we lost the 3 candidate justices, and at a meeting, I'll never forget this, they said, "We need to educate the public." And I stood up and said, "You know what, I think we got educated, and we better start thinking about it, how we're going to do it." Shortcomings, we haven't really educated voters about the difference between a regular election and a retention election. We just haven't given information on the process of the merit system of the row or the voter. One thing as a senior judge I'm volunteering to do, and I get credit for time, I have to put in 65 days a year, and I keep track of the time. And so one thing I'm thinking of doing is, if any of you know have a community group that wants to hear about how we select and retain judges, I'll be glad to come speak, and I think I'm going to hit the trail on that. Going to talk to the Chief Justice about it. Here are the lessons from 2010 that I have drawn. One, the broad lesson is judicial independence is really threatened, and specific consequences. Minnesota was thinking about going to the Iowa. They have a sort of an election system. I don't quite understand it. They were thinking of going to the Iowa system, and that went by the wayside after we lost 3 justices. Kansas, I don't know if any of you read the New York Times last week about this, but Kansas legislature, as they're working on passing legislation, giving the legislature the authority to impeach judges or justices whose rulings tend to usurp the functions of the other branches. Now think about that. You talk about really threatening judicial independence. And of course we have Governor Brownback, a conservative guy. What's happened is the Kansas legislature is about 3-to-1 Republican, conservative, and 4 of the Supreme Court justices were appointed by a previous Democratic administration. And they did, the justices had what conservatives consider an anti-abortion, anti-abortion ruling, and did some things with school funding. They ordered the legislature to make sure the funding's fair. What a unique idea. And they're going to make a real run at these 4 justices in the retention election. Kansas has the same situation we do in terms of their setup. Our nature of our response should change. I watched, we had just 2 very bright people out in 2010, Justice Bob Albee, former justice who's a Grinnell graduate, and former Justice Mark McCormick. And they would argue against Bob Vanderplaats. And they made great arguments, you know, Federal 78, maybe Tocqueville, and then Bob Vanderplaats got up and my wife's a priest, so I'm very careful about it. He cited what he thought was biblical reference to, and what he cited as baloney, but you know, the saying there should not be same-sex marriage. But we spoke on different levels. He spoke to the hearts of the conservatives who opposed same-sex marriage just because they didn't like it. And we spoke to the concept of fairness and judicial independence, which really didn't resonate. Sort of like speaking to the militiamen up in Wyoming about gun control. You know, you're not going to get very far. You better figure out how to conduct the conversation a little differently, which we'll talk about next week. I don't know what's going to happen. You know what? In my years on the bench, 28 years as an active judge, I went 1 year without a raise, my first year. And I could always count on a raise, which is nice. No raises since Barnum 2009, except for last year, 2.5%. Now, I don't think legislators would say we're punishing the judges, but I think that's, I submit to you, that's a fair inference of what has happened. Remember, Federal 78, we don't hold the power of the purse, and so that is really tough on morale. Well, what information, this is what you can get on a judge if you really want to dig. I shouldn't say that way, that's if you really want some solid objective information. We have to file a 60-day report every month, letting with Supreme Court, letting them know what decisions are over 60 days. We have to, I just listed my financial disclosure. Got to file that. You can get a record of any disciplinary actions. You can look at written decisions. Reversal rate. If the judge is reversed 50% of the time and the average reversal rate is 80, then that should be a red flag. But I say be careful there, because some judges, I hope you don't state this publicly, but some judges do tend to try to duck hard things. And some judges willingly take on hard cases that automatically have appeal written all over them. So, you know, if somebody gets convicted in a murder case, it's an automatic appeal. Remember Socrates, the Bar Association does a plebiscite, and they evaluate judges. The lawyers get to evaluate judges on all these things. The law, factual, punctuality. This is where I needed you to get me. I sort of didn't get expert or great marks. I did okay on punctuality, let's suffice it to say. Attentiveness, management of the courtroom, that's part of our job, is to run things in there. And temperament and demeanor. Here's some other criteria. You go online to the Bar Association website, and I can help you when the election comes if you want to get in touch with me, or to the Iowa Judicial Branch website, and you can see each judge rated on all these things from 0 to 5. So we get new judges. There's a week-long new judge seminar in Des Moines. I'm on the faculty for that. That's in November. Usually we have 10 new judges every year. And then they get to attend a National Judicial College at Reno. You know, that seems oxymoronic, doesn't it? It's a good school. When I went, it was like six weeks. Okay, what do judges do, and how do they do it? You know, my chambers, I've got thousands of rulings neatly indexed, and if I have a case, the neat thing about being on the bench so long is I say, oh, I did a case like that 5 years ago. I'll find the ruling and check the law to see if it's changed. And then I don't have to remake the wheel. So that's my body of work in deciding cases. So you'd think it's easy for me to describe the process that I have used thousands of times, but it's not. You know, I could say, wow, you wouldn't understand that anyway. But that would be a pretty ignominious retreat. Yes, sir?
Do you do that all on your own, or do you have aides that you tell them to look up this and that?
Good question. The budget has been really tight. We used to have 2 law clerks for 9 judges. Now we're down to 1 law clerk for 9 judges. So the answer pretty much is no, we do it on our own. And I have a court reporter who also serves as my secretary too. And then the question is, if I'm doing something real hard, like should I mistry a high-profile murder case, and I'm thinking about that over the weekend, I frankly am not going to rely on somebody just out of law school to help me decide that. I think that's an abdication of the judge's responsibility. I knew one judge had the clerks write his opinions. I know at the Supreme Court level, U.S., I've heard clerks write the opinions. Personally, I don't like that. I think that's an abdication of the judge's job. How do I decide cases? I would use the same technique I used on law school exams or what I use in personal life. I mentioned this before. I ask the big question, what do I have to answer? Then I try to figure out what questions do I have to answer to get there. What do I look to when I decide a case? There's a really good book. You can see this is called The Nature of the Judicial Process. Justice Udenhop recommended it to me years ago, and I've read it many times. It's been through a fire and it's still there. But I look at it as Justice Cardozo looked at the nature of the judicial process. Said the rules and principles have never been treated as final truths, but as working hypotheses to be tested every time in the courtroom. So when I went in to do a trial, I looked at it as, okay, how's this going to work out? And I kept notes on if something didn't quite work very, very well. So there are 4 basic steps. Yes?
I have a question. How do you get a record of the trial that went on? What process do they use for that?
How do I get a record of the trial that went on? Good question. My court reporter takes down everything that is said in the courtroom, and that's really a computer. I did 4 murder cases in 1 year. My court reporter got to buy a $20,000 system with the transcripts money. And the other thing is that I typically would have real time. So as my court reporter would type, I had 2 computers up there, and one was recording everything that was said in English. So I had that to store too.
You mean it's actually printed out?
It's actually verbatim printed out. She uses a shorthand form, comes up on my screen, verbatim. And you want to appeal a murder case, come up with about $15,000. It's, $3, $4 a page in copies. It's I'd kid her after a day in the courtroom when I knew something was going to be appealed. I'd see her come out with a bunch of notes. I said, well, that's a good day for you. That's a lot of money in your hand. I didn't say that in front of the lawyers. But one court reporter got in trouble, and actually I think she went out and told the lawyers, this isn't Waterloo. She said, you know, my judge was just dead wrong on that. And I think you should appeal it. Yeah, she was gone pretty quickly. Was there another question? Okay. Yeah, I don't mean to sound like the mafia, but my court reporters were very loyal, and I was loyal to them, and I just explained, this is how it works. You're the only person that, I'm the only one who's going to care about you in the courtroom. Probably the only one that's really going to care about me is you. So we are going to be loyal to each other, and that's how it worked from the get-go. But what do? We find the facts, find the law, interpret the law, and apply the law to the facts. That sounds simple. Finding the facts, I ask myself typically, first question, what's going on here? I had a cave-in in a trench in Mason City, and everybody thought that they're covered by insurance. There are a whole bunch of contractors, subcontractors, and of course they sign all these insurance policies with subrogation clauses, and they never look at them. So of course somebody gets hurt in the cave-in, and I had to try to figure out, who pays what. But I asked that question, what's going on here when the cave-in occurred? Then of course you got to make inferences from the facts, and we've had training in this. You got to evaluate testimony, and then if experts are involved, you have to involve them. And then we have to evaluate reliability of testimony, and see if I can go to the... And there are essentially 4 steps to perception. We use our senses. You've got to remember what happened before you come in the courtroom, and then you've got to be able to say it in the courtroom. And sincerity. We want to get the truth as much as possible. If you want to read about unreliability of eyewitness testimony, Elizabeth Loftus, a psychologist, has a great book. Here's a pictorial representation of the process in the courtroom. So an event occurs in reality, and then it's got to be retained in memory, and then the witness narrates, and the judge is finding facts. Well, think about what's cross-examination about. First of all, some people perceive things better than others. Next, we all have little tapes in our minds, but some play better than others. I noticed mine's not playing as well as it did, 30 years ago. And then some people narrate things better. Some are comfortable talking, others more comfortable writing. So let's see how somebody just got up and left. Was it male or female?
Female.
Female? Okay. What can you tell me?
Tattoos on the arms.
What's that?
Tattoos on the arms.
Tattoos on the arm. What kind of tattoos? What do they look like?
Wearing a t-shirt.
Wearing a t-shirt. What color?
Gray.
Red?
Gray.
Gray. Okay. Okay. Did she have shorts on or slacks? Blue jeans.
Blue jeans.
Was she wearing glasses?
No. Hair in a ponytail. Hair in a ponytail.
Wow, we got some good. Come on in. Wow, we got some good witnesses here. Thank you.
can tell you, she hit me on the way out, that's all I know.
Thanks, Doug. Hard or softly?
No, she had it bounced off of me. I could tell she was kind of big or carried a purse or something.
Well, here's the challenge that, I talked about DNA, and we'll probably talk a little on this before the Second Amendment. But what I find over the years, the challenge of complexity, this is what Judge David Hamilton said about it. We don't have the luxury of functional illiteracy when we're dealing with technology and technological improvements. I mentioned when I started, we didn't have DNA. Multiple regression analysis used in discrimination cases. Thank God I took a lot of math at West Point and then literature and history here. But I went to school for a week in multiple regression analysis so that forgive me, one of my friends used this term, but before I went to school I didn't know poop and peanut butter about multiple regression analysis at all. Just no idea. And then use of computers. We didn't have computers at all. I had to go into the library to look up things. How do we combat this? We have an annual conference. George Mason University Law and Economics program I used to go out to 2 or 3 times a year. It's now known as Antonin Scalia School of Law. Somebody gave $20 million and said, would you name the law school that? And they said, okay. But they're changing it because of the acronym. And I have a good friend, Henry Butler, who is the dean now, and I'm waiting to talk to him. He used to be at, this program used to be at Kansas, and then Brookings AEI, they gave us the balanced approach. And so I would go out to those, environmental economics, which happened to be in Tucson in January. Economics of property and liability rules, toxic torts, which that was a week long, and I'm glad I went to that because then when I get back, the court administrator would say, aha, we have somebody who knows about toxic torts. You can do that asbestos case. Or you can do the cloud that arose from the chemicals. Here, I just raised this as a query. When they come to the feast of a great liberal arts education across the street, our future judges and lawyers serve by letting them select freely from the menu of courses. And I know I'm going against the tidal wave here. I think not. If I were doing pre-law, I'd say you're going to be over there in physics and chemistry and history. I'll talk about originalism next week in the Second Amendment. Bad idea for lawyers. We are not very good historians. Historians are good historians. And we do things, as you can tell, more anecdotally. I'm not a good empiricist, but I learn enough to figure out what the empiricists are telling me, like the Harvard pathologist at the asbestos trial talking about. We have 5, or we're about finished? We're finished. Okay, let me see what. Okay, well, I'll start next week for just a little bit before the Second Amendment on where we find the law. There was a couple of good questions about that. So thanks today. Enjoy the day.
Thank you, Judge Carroll. That's something we knew nothing about before, so we really appreciate that. Thank
Could I
you.
say one more thing?
Sure.
Okay, thanks, man. Oh, if you want, for next week, you could go online and Google U.S. versus Miller, a 1939 case. That's the militia view. And then D.C. versus Heller, 2008 case. Do it when you're pretty tired and want to go to sleep. Thank you.
And if you have cards that you want to fill out to ask a question for the judge, feel free to do so, leave them on the table. And Nisha here has some pens if you need something to write with. Well, next week I will not be here. I'm going to be visiting my family in California, but Joanne Britton will be your host. So looking forward to you all coming back, and I have another great class for you next week. Thank you for coming today. Have a good afternoon.